Notorious history sheeter Zenito Cardozo, who was arrested under the stringent National Security Act and then later released on interim bail, has all charges dropped against him following a mistrial. Cardozo's lawyer Amit Palekar said when his client was arrested under NSA and the way it was applied to him was wrong, and that was their major case during the trial. It is a clear-cut technical error, and there are judgments of Supreme Court and High Court which say that this is a case of gross violation of rights of an individual which cannot be taken away, stated Palekar.
See, ultimately, justice prevails is what I have to say. कारण जी ज्या तरेने NSA लावला गेला and the way it was applied to him was wrong. That is what our case has been right from the beginning. First of all, कि NSA, whether it was threat to national security or whether it was threat to public, was what not considered by the government. By non-application of mind, certainly and suddenly NSA is applied to a citizen. No doubt there has been criminal cases pending, but doesn't mean that a person is a national threat so as to invoke NSA. See, they said that there are various cases pending. They said that he is involved in criminal acts, which there's assault on Iris Rodriguez. That was one of the case. There was another case which involved Section 302, which is thereafter watered down that to say that it is a case where defense, he did it in self-defense. Now all these cases are pending trial. Now when these cases are pending trial, the same cases are used to invoke NSA, and which according to me was absolutely a wrong thing to say that. I mean, there was no public, that there has not been a case where he is involved in rioting or creating nuisance or in any manner affecting the threat or national security or of the state itself. So these are the grounds on which they had invoked NSA, and of course we challenged it on technical grounds as well as on the merits of it. In fact, there has been delay. There is within 3 weeks time they had to make a report to the advisory board, and thereafter within 7 weeks of detention they had to the advisory board had to make a report saying whether it is proper detention or illegal detention in that sense. Now that was not done within time. That means just for showing the people, or rather just for showing or rather to make out unnecessary a false case, they invoke this, and thereafter it was not pursued seriously. This is to show that there has been absolutely an illegal detention which is supported by the machinery of the government, which is wrong. It's a clear-cut technical error, and there are judgments of Supreme Court and High Courts also which says that this is a case or gross violation of the rights of an individual which cannot be taken away very easily. Liberty or right to live proper life under 21 or arbitrariness under 14 of the Constitution is challenged here, and High Court has said that it is correct that you have technically failed in this case. That's why it is quashed and set aside.